Major breaking news. The United States Supreme Court has given a huge legal victory for the January 6th defendants and for President Trump by knocking out an interpretation by the Jack Smith Department of Justice that's been used and abused to try to put people in prison and to convict them of crimes that are not crimes. Specifically, the U.S. Supreme Court today explained that 18 U.S.C. 1512C, which if you violate it carries a decade in prison, does not apply to the January 6 protesters and was designed for other things, specifically destroying documents in the context of a criminal or civil lawsuit or case in court, having nothing to do with slowing down Congress from counting electoral votes on January 6th. We're going to break down this big win for President Trump and for the January 6th defendants when we come right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed, What the 10/7 Terrorist Attacks Teaches Americans About the Right to Bear Arms. We must always learn from the mistakes of others. The Israeli government and the Israeli people made a big-time mistake in not encouraging the private ownership and use of firearms for self-defense. They talk about how they never should have forgotten certain lessons after World War II. And in my view, and I explain in the book, Israel Disarmed, the Jews and the Israelis forgot the most important lesson that they were never supposed to forget after the Holocaust, which is don't allow yourself to become disarmed and don't rely on the government to be there for you, because it simply, in most instances, will not be there to protect the lives of your life or the lives of others. Critically important lessons about Israel and throughout history in the book Israel Disarmed. Check it out on Amazon. All right, folks, major breaking news. The United States Supreme Court, as I predicted and as we talked about earlier this year, in the United States versus Fisher case, the United States versus Fisher case has concluded that the use by Jack Smith, the anti-Trump prosecutor, in a case against Donald Trump, and the Department of Justice generally under Merrick Garland, under Joe Biden, who have been using the statute 18 U.S.C. 1512C to either threaten January 6 protesters or indict January 6 protesters under the statute, which is known as an obstruction or tampering with official processes statute, but carries with it a decade in prison, 10 years in prison, by using this statute as leverage, as an intimidation tactic, even though it was clearly not designed for anything associated with like a January 6 protest or anything associated with Congress. The Department of Justice and Jack Smith has been using this statute to intimidate people into pleading guilty to lesser charges, and they've used this to indict President Trump, and this is the one charge that carries significant prison time for President Trump in that indictment by Jack Smith in D.C., and the Supreme Court today rightly concluded that the language of 18 U.S.C. 1512C, an obstruction of justice statute, does not apply to simply acting in a way that delays the counting of electoral votes on January 6, 2021. And that what the statute's all about is thwarting people or discouraging people or penalizing people who have either destroyed evidence or tampered with witnesses in the context of a civil case in court or a criminal case in court. This has nothing to do with an official process in Congress or otherwise. It's all about screwing with evidence or witnesses in court cases. And that's what in a 6-3 decision, the Supreme Court ruled today in United States versus Fisher. Now, just as a reminder, because I think this is some geeky lessons here, but I think it's helpful for you to understand how to think about interpreting statutes. And again, this was an abusive process, in my opinion, for the Department of Justice and Jack Smith against Donald Trump to even consider bringing these charges. It's pathetic and bullying, intimidation, to bring nonsense charges that you in good faith should know don't apply. Typical overreach by government prosecutors, which occurs all across this great country, unfortunately. But talking about prosecutors and my view of them is for a separate video. But I've got some real views. But that's a whole separate issue and a whole separate video. All I'm going to say is the U.S. Supreme Court agreed with me that this was a nonsense attempt to punish people through intimidation by bringing bogus charges under 18 U.S.C. 1512C, which is a statute that arose out of the Enron financial scandal, and as to how an Enron financial Wall Street scandal involving destruction of evidence can somehow give rise to charges associated with allegations of a delay of a vote in Congress is absurd, especially when this exact same statute was not used against anybody that, for example, was protesting or complaining about the nomination and confirmation in the United States Senate of, let's say, current Supreme Court Justice Brett Kavanaugh. No, this was specifically designed by Trump, against Trump supporters, by the Joe Biden Department of Justice and the special prosecutor Jack Smith, who's been hired to go after President Trump. But let's talk specifically about the two concepts that the court used to explain why this was obviously not applicable to the January 6th protesters. As a reminder, the relevant language of 18 U.S.C. 1512C provides, whoever corruptly alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding. Or, and here's the key, because it was this or that the Department of Justice and Merrick Garland and Jack Smith wanted to use and did use against the January 6th protesters and against Donald Trump out of D.C. Or, quote, otherwise obstructs, influences, or impedes any official proceeding or attempts to do so, shall be fined under this title or imprisoned not more than 20 years or both. 20 years or both. So there you have it, folks. 20 years in prison, up to 20 years in prison if you violate the statute. Big time problem. Now, here's the game. If you look at the language that I showed you, it's the otherwise obstructs or influences language. So during oral argument in the Fisher case, Chief Justice John Roberts asked about the doctrine of estudium generis, which basically just means of the same kind. And he asked about this because it is a basic rule of interpretation that if you have a list of issues in a sentence, and that sentence ends with or otherwise, or similarly, then the reference to or otherwise must refer back to be of the same kind of thing as what came before it in the sentence. The example I gave in my video I shot earlier this year was, think of the following sentence. If I say to you, look, you are not allowed to go to a baseball game, a hockey game, a football game, a soccer game, a cricket match, a tennis match, or otherwise. In that context, under the doctrine of estudium generis, a Latin phrase, again meaning of the same kind, the language at the end of that sentence, or otherwise, must refer back and be of the same kind as the rest of the items listed in the sentence. And because the sentence I just gave you about baseball games, football games, hockey games, etc., all refers to sporting events or otherwise, the proper way to interpret that sentence, if you're a lawyer, when you see or otherwise, is that or otherwise refers to any or all similar things. And in my example, sporting matches, athletic contests. What the Department of Justice was doing here, after there was a description of court cases, criminal cases, legal cases, and then it says or otherwise messes with an official proceeding, what the DOJ was trying to do was to say the or otherwise official proceeding or other official proceeding, that could mean any official proceeding, which in theory could be screwing around with a town meeting, a meeting of the mayors, a city council meeting, or in this case involving January 6th, delays or obstruction or any interference with Congress's counting of electoral votes for the presidency from the 2020 election. So what the Supreme Court did today in Fisher, and this should not be that hard, is they looked at the list and they said, we look at the list in the statute and it's all talking about criminal and civil trials, court cases, or otherwise an official proceeding. And the court says that obviously the or otherwise must refer back to the prior part of the sentence, which is talking about civil and criminal court cases in courts. So DOJ was trying to say or otherwise means any kind of civil proceeding or any kind of official proceeding that you obstruct with. That can get you put in prison. And the court says no way, no how. That or otherwise language at the end doesn't mean everything under the sun. It refers back to the court cases referred to in the early part of that sentence in that criminal statute. And therefore, it doesn't encompass the official process of counting electoral votes by Congress on Capitol Hill, because that obviously is not a court case. It's not a civil court case involving a lawsuit. It's not a criminal court case involving a criminal prosecution. And therefore, under that doctrine of est judum generis, the or otherwise language at the end doesn't mean everything under the sun. It has to be a court case. So basically, they said that the DOJ and Jack Smith was playing games, and all those indictments under 18 U.S.C. 1512C involving anything associated with January 6th go bye-bye, bye-bye, cannot be used. And that is a terrible blow from the Department of Justice and the anti-Trumpers out there that are trying to use this to put people away in prison for 10 or 20 years, or at least threaten them with long prison sentences, forcing them to take plea deals that are admitting to all sorts of things just to avoid the possibility of going to prison for decades. And now that this statute is out of there, this takes away a tremendous amount of leverage from the Department of Justice in the deep state and from Jack Smith against Donald Trump, because this is the one felony that they had in their back pocket to hit people with. And now that this is gone, the leverage that the government has over a lot of these, not all of them, but a lot of these January 6 defendants has gone bye-bye. So a very interesting development. Again, I'll put a link to the decision down below, 6-3. The only other thing I want to bring to your attention here, it's quite interesting that Justice Barrett actually was in the dissent. She was one of the 3 dissenters that actually thought that the law could be applied sometimes here. And then it was Justice Brown Jackson that flipped into the majority. Keep in mind that Justice Brown Jackson used to be a public defender. She used to be a criminal defense lawyer, so I think she has a little bit different perspective, in some ways anti-government in some instances when it comes to these sorts of things, and I'm happy to see that. And by the way, as a general matter, if you give me the choice between appearing in front of a judge who was a former public defender or criminal defense lawyer versus a former prosecutor, as a general matter, not always, but as a general matter, I generally prefer being in front of someone who used to be a criminal defense lawyer or a public defender. As a general matter, I think they have a little bit more of an anti-government bias, a little bit more sense of the games that prosecutors and government plays to put people in prison. So I, generally speaking, am more interested in appearing in front of those kinds of judges than former prosecutors. But again, that's a very, very broad generalization. It doesn't apply all the time. But anyway, just some food for thought. So anyway, there you have it. Big news today. United States versus Fisher, a big win for the January 6 defendants and President Trump, who was also indicted under this provision. That all goes bye-bye, and good riddance as far as I'm concerned. But those indictments never should have been brought, because this is clearly not designed for what happened on January 6 with those protesters and the trespassers on Capitol Hill. So there you have it, folks. Hope you learned something here today. Make sure you subscribe to my channel, The 4 Boxes Diner. Don't forget to follow me on X. We have over 16,000 followers on X now, at 4 Boxes Diner. And we will see you again soon here at The 4 Boxes Diner.
Orders up. Table 2A.